Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Arpitha Kodiveri, a graduate student at the European University Institute. We will discuss her article, Wildlife First, People Later, Forest Rights and Conservation Towards an Experimentalist Governance Approach, which is published in the Journal of Indian Law and Society. So, welcome to the show, Arpitha.
Thanks, Brian. Thank you for having me.
Yeah, no, my pleasure. I'm really glad that we met up on Twitter, and I really was interested in your paper, and especially in sort of the background or context in which you wrote it. So I wonder if for people who might not be so familiar with kind of Indian history, Indian conservation, and Indian peoples, you could talk a little bit about the context in which you're writing this paper. I mean, what's really at stake in the problems you're describing?
Absolutely. So, India's forest conservation story is deeply tied to its colonial history. So, a lot of the forest laws that continue to inform forest conservation today were a product of that colonial encounter. So, sort of the logic of conservation from the colonial period to independent India was to assert state control over these resources and to make sure that they have access and control to use these resources for economic purposes, whether it was timber or coal mines or iron ore. And the problem in India's forests is similar to many forests in the global south, which is the overlap of interest of indigenous communities or Adivasi communities and what has now been categorized as forest dwelling communities in the Indian context, who have been denied their rights over forest land and access to resources because of the idea of exclusionary conservation. And by exclusionary conservation, what I basically mean is laws which provide for complete state control to the extent that any human interference or use of resources is seen as something that takes away from the pristine nature of the forest and has an adverse impact. So there's a tension there basically, and my paper tries to address that particular tension, which was amplified because a case was filed before the Indian Supreme Court, which challenged a progressive law, which is called the Forest Rights Act, that actually recognized the rights of forest dwelling communities. But unfortunately, corresponding reconciliatory amendments were not made in the older forest regime.
Well, maybe you could talk a little bit about the particulars of one of the disputes between forest dwelling communities, the government, and conservation groups, so people can get a kind of a better picture of sort of what's really at stake. I mean, how large are these communities? How large are the forests in question? And what are the nature of the disputes between the forest dwelling communities and conservation groups and the government?
Right. No, I think that's a great question. So, in terms of the scale of this conflict or this dispute, right, it's 8% of India's population are categorized as what is known as scheduled tribes or Adivasis who are dependent on forest resources for their livelihood. So, that's a large number. And the nature of these conflicts really varies. But an example that immediately comes to mind is one of the case studies that I'm working on for my thesis as well, where there's an expanding coal mine in the forest of Sundargarh in Orissa, which is the eastern state of India. And the dispute there is, twofold. One, the communities are being relocated because the state has absolute control over these areas, what are categorized as coal bearing areas. And at the same time, you have conservation groups trying to kind of look at the climate change angle to this particular dispute. But funnily enough, the idea of climate justice has not really informed these struggles to a great extent. I think another example that could be useful is in the 1970s in India, tiger conservation became a priority for the government in terms of passing legislations. So you had Project Tiger, which was largely focused on this issue of tiger conservation, and it created what came to be known as tiger reserves. And conservationists pushed for these areas to be exclusively areas that, the tiger inhabited, which meant that the communities who lived within these tiger reserves were to be relocated. So that is at the heart of this conflict, which is the exercise of rights by the indigenous communities is seen as violating the rights of the forests and the tiger. But the more you dig into sort of political ecology and the growing sort of discourse in ecology now, it's transforming. It's really not tenable to sort of push communities away and create these what they call inviolate areas or areas which are purely for the purpose of conservation.
Well, so maybe you could talk a little bit about the Forest Rights Act. Like, when was it passed? What was it supposed to do, or what was it intended to do? And where have tensions arisen between the act and sort of its purposes and the needs of indigenous peoples?
So the Forest Rights Act was passed in 2006. It was passed at an interesting time in India's, political movement because we had a lot of rights-based legislations being passed between that, year of 2006 to 2011. And what was interesting about the Forest Rights Act was it's a product of the social movements, constantly asking for a legislation that recognizes the rights of these communities. And the Act, in essence, tries to do that. What it does is it recognizes a range of rights of forest dwelling communities, which includes a right to homestead land, the right to cultivate for self sustenance, the right to conserve what is historically an area that the indigenous community has been conserving. And it tries to, in many ways, allow for the voice of these communities to inform decisions of conservation. It was in many ways also, I would term it as quite a radical and rebellious law. And I say that because it's trying to undo a history, an institutional history of conservation that has always functioned in the paradigm of excluding forest dwelling communities. So it's pitting one legal regime against the other. And that's also been one of the difficulties that the Act has faced in its implementation.
When problems have arisen between the Forest Rights Act and the interests or needs of indigenous communities, what's kind of been the source of those problems? What's kind of causing the tension or dispute here?
So, the interests and needs of forest dwelling communities, again, is very difficult to articulate in one voice, right? Because it's a heterogeneous community, they have a multiple set of interests. They're also, in many ways, engaging with the market and the state in myriad of ways and evolving. So, there are conflicts and tensions sometimes, between particularly the forest dwelling communities, which are legally categorized as the scheduled tribes, and those who are not scheduled tribes. The Forest Rights Act itself creates this artificial binary. What it does is it says that communities who've been legally categorized by the Indian state as scheduled tribes under the Indian Constitution, which is basically a list of communities who've been identified historically as being marginalized and living independent on forest areas. And then you have another set of communities who are not categorized as scheduled tribes. And so they have then, within the law, required to produce evidence that they have lived and depended on forest areas for a period of 75 years. And it's a difficult ask for a forest dweller who in many cases and many instances in interviews that I have had seldom have access to that kind of evidence. So when they do apply for their rights within this law, which is supposed to recognize their rights, it seldom does get recognized. So there's a high sort of rate of rejection, particularly for their claims to forest land or homestead land. And that has created a lot of tensions on the ground within the communities. The other challenge has also been this idea of the scheduled tribes being sort of naturally attuned to conserve, or what they call themselves, or some of the bureaucrats that I've interviewed have categorized them as sort of a worthy steward. They've historically kind of inherited this kind of traditional knowledge, whereas the non-scheduled tribes are seen as not bearing this history and cultural lineage, and harboring this traditional knowledge to be able to conserve. So that's created a lot of tension on the ground, and also sort of informed some of the claims that the organization Wildlife First, which has filed a case before the Supreme Court, has also used to its advantage to some extent.
Do you think this distinction between the scheduled and non-scheduled tribes is a fair or accurate one?
I think it's very contextual in terms of who has been categorized and who hasn't. So let me first address the question of fairness, right? The criteria for being recognized as scheduled tribe is quite in some ways, a lot of scholars have argued that it is quite discriminatory because it has terms like shyness, geographical isolation, backwardness as sort of the criterias that communities have to be able to fulfill to be recognized as scheduled tribes. So there's that particular sort of critique. So inclusion into this list already becomes difficult. And once included, of course, a lot of benefits follow. But it's this, delicate dance of inclusion and exclusion that has sort of guided state decision making on recognizing communities or not recognizing communities. I remember once when I was in Uttar Pradesh in northern India, there was a story where in one village, a community called Kol was recognized as scheduled tribe, whereas just across the border into the other state, they were not recognized as scheduled tribes. So marriage between those two communities were not happening because of this inability to, claim this particular legal categorization and the benefits that follow with it. So that's just an anecdote. But yeah, so the fairness question is a tough one. I think it's important to be able to legally categorize these communities in order to understand what benefits and protections they deserve. But I do think the framework that guides that at the moment is fairly redundant to some extent, and I think it needs a broader framing that allows for the inclusion of other communities as well, because you have a lot of lower caste or Dalit communities who are also dependent on forest areas, and they have their own history and story of marginalization.
Well, based on your paper, it sounds like some of the conservation groups sort of pushing Forest Rights Acts related claims have ideas about how those claims can be squared with the needs of interests of indigenous peoples who are making claims on forest land as well. I wonder if you could talk a little bit about sort of how conservation groups see this problem and what they're missing.
So, the way conservation groups see this problem is they think about communities living within forests as communities experiencing a development deficit. And what I mean by that is rigid conservation laws restrict the extent of quote unquote development that can take place in the form of infrastructure, for instance. Because even if a road has to be built, it has to go through a rigorous process of approval, and the forest department then, sort of eventually makes that decision. Similarly, access to education and healthcare, even electricity, is quite difficult in these remote areas. So, conservationists often feel that if communities are relocated from these forests, then automatically they gain better access to education, healthcare, and other basic facilities. While some of it is true, because I have personally witnessed in my fieldwork in different, tiger reserves and other spaces, that communities do lack access to education and healthcare. The aspect that these groups are definitely missing is the cultural attachment that these communities have to the land, and the cultural kind of bond that they share, not just with the forests, but with the creatures as well. So, the idea of relocating communities is also an exercise of breaking their cultural links to the land, and very often that is something that conservation groups are very tend to miss and tend to look over.
Well, so your paper is sort of framed around a particular dispute that came before the Supreme Court. I wonder if you could talk a little bit kind of specifically about that dispute and whether the Supreme Court has resolved that particular dispute or not.
So, the particular case that I refer to in my paper is a case filed by a group of conservationists um, called Wildlife First, and there are other nonprofits as well. And they challenged the constitutionality of the Forest Rights Act. And their basis of challenging the constitutionality was the provision, Article 14 of the right to equality, where they basically stated that this particular law, by recognizing the rights of certain communities to forest land and not others, was violating this article. And it went on into sort of other articles within the Indian Constitution. But the challenge that it definitely posed, if one were to look at the forest law regime in the Indian context, was it was challenging the conservation practice of excluding communities and creating these inviolate spaces. And a lot of these groups have had a history of working in tiger reserves and assisting the forest department in relocating forest dwelling communities outside of these forests. So it comes from a certain understanding of what conservation really means. The Supreme Court has interestingly passed, a series of interim orders and several other sort of orders that have stemmed out of this particular case. And in February of 2018, what it did was it ordered for the eviction of communities whose rights had not been settled. And this was sort of a clear violation of the Forest Rights Act, because the Forest Rights Act doesn't necessarily have a deadline within which implementation has to take place. So that created a lot of uncertainty and panic within the forest dwelling communities across India. But eventually the Supreme Court sort of stayed this particular order and has now focused its attention on the implementation of this act, so the mechanics of it. For instance, it's now asked the states to submit reports of how many claims have they rejected, on what basis have these claims to forest rights been rejected. What is the kind of evidence you're using for the recognition of these rights. So it's quite an interesting case and quite a telling case on the role of courts or judicial overreach in environmental governance, because a case that began as a challenge to the constitutionality of the act has now transformed into a case where it's trying to be prescriptive about the day to day functioning of the forest department and the other institutional bodies involved in implementation.
So is the case that you talk about in the paper still an ongoing case then, or has it been resolved?
It's still an ongoing case, so the hearings are still happening.
Well, so in your paper, you recommend a particular kind of perspective or way of looking at, considering, and hopefully resolving the kinds of problems that you're discussing in kind of a more quote unquote experimental way. I mean, I wonder if you could talk about the approach that you're suggesting and whether elements of that are or maybe aren't reflected in how the Supreme Court and other institutional bodies have been addressing the kinds of disputes you're talking about.
Absolutely. I think one of the realizations as I started working in this space was that conservation is a wicked problem, but it's also deeply informed by the contextual realities. So the idea that that guides conservation law and policy in India in this current movement is is quite a it's quite a sort of one would describe it as pitting one approach against the other. There isn't any middle ground, and what I mean by that is either you have laws pushing for exclusionary conservation, which I've been speaking about, or you have the Forest Rights Act, which speaks to complete community control. And the reality on the ground is very different because, as much as we'd like, the idea of self determination and complete community control, communities continue to depend on the state for different kinds of welfare services as well as assistance on law enforcement, for example, if there's a case of poaching. So, the approach that I suggest is to find that elusive middle ground. And the idea of experimentalist governance, which originated in the context of climate change, was a fascinating one because it was not too prescriptive. It allowed for localized solutions to be able to inform these decisions. And the broad framing that it speaks to is to have a rules based framework that guides all these decisions, but leaves enough room that the solutions within that rules based framework can be worked and reworked through an iterative process. That might sound a bit abstract, but to sort of make it more granular and applicable to what I am saying is if in India's forests we say have a particular area which is used by the community for grazing, but also comes within the boundary of what is termed as a tiger reserve or a national park, which you have plenty of in the US as well. There's a way in which these decisions of this particular area will be used for grazing this year, and then there's perhaps a shift so that the landscape regenerates, are sort of localized solutions that one can see operating across the board. So why not make room within the law and the governance structure to enable these sort of problem solving techniques at that granular level, as opposed to something that continues to pit the forest department or the Indian state against forest dwelling communities, because the solution, as I say in the paper, is somewhere in between.
As I understand it, this paper is just one sort of iteration of a larger scholarly project that you've embarked on. I wonder if you could talk a little bit about your research more generally, sort of what have you been doing in this area and sort of what are your broader goals with this particular research project?
So I'm right now working on my PhD. So my PhD actually looks at the provision of free, prior, and informed consent, which is a legal provision where it makes it essential to obtain consent from the indigenous community before land is acquired for any development project. So I look at that provision and it's sort of how it entered into the Indian context through the Forest Rights Act and how it's being implemented at the moment. And in it, argument I try to make is the importance of deliberative democracy in decision making around conservation and development in India's forests, because, like I've been saying earlier as well, India's forests have seen two competing priorities shape the realities of these communities. One is exclusionary conservation, and the other is extractive development. And so, how does one look at deliberative democracy in such a political context, and how does a legal provision like consent enable or limit that possibility?
Well, so maybe you could talk a little bit about the kind of on the ground research that you've done. I mean, it sounds like you've been doing a lot of work at a kind of theoretical level of looking at what the law says and how it works, sort of in theory. But in addition, sort of on the ground, talking to people and understanding how these disputes kind of play out in practice.
Yeah, so a lot of my writing is informed by fieldwork. So, what I've essentially been doing before I embarked on a career in academia was I was practicing as an environmental lawyer for about 4 years, where I was working closely with these communities in 3 states in India, uh, assisting them in filing these forest rights claims or other disputes that they had with the administration. So that kind of set me off into a scholarly career that is quite heavy on the practice side. So uh, even though I'm trying to aim for these theoretical arguments, they're informed by interviews that I have been doing in the eastern state of Orissa. In particular, I've been doing fieldwork in Niyamgiri, where there was a proposed bauxite mine, but the community managed to, secure their rights over that sacred hill. The other is in the coastal part where a steel plant is being set up, and trying to look at how communities are resisting the acquisition of land and how they're using the law there. And lastly, it's the expanding coal mine in Sundargarh in Orissa. So, in many ways, my work takes me around Orissa quite a bit, and it's long journeys in rather uncomfortable buses, but it's very enriching, and I wouldn't trade that for anything else.
Well, Arpita, in closing, I mean, it struck me reading your paper that you're talking about this really kind of fascinating and difficult problem around forest rights and indigenous peoples, in one particular context. But a lot of the observations that you're making in the paper and in this interview seem like they might have broader implications about kind of Indian society and Indian kind of constitutional questions. I wonder if you could briefly reflect on those.
So, one of the things I feel like this particular area of research informs us about India's democracy is it's always been a site of contestation, but it's always been a site of contestation for communities who've been able to gain some kind of political clout. And what's interesting about forest dwelling communities is they historically had one very prominent leader during the making of India's constitution, Jaipal Singh. But ever since, there have been some movements which have gained that kind of political clout and the ability to shape the discourse. But it's only been social movements and protests ever since that have led to some kind of legal gains. And just studying that particular interaction between, India's democracy and how it's shaped by social movements, but also how the law, in many ways, is becomes that tool for expressing or articulating these interests. So that I think is quite a bit of learning that's happened.
Thank you so much. It's been a real pleasure talking to you about this paper and about your broader project. And I look forward to reading more from you about these really interesting and contentious problems.
Thank you so much, Brian. I really enjoyed speaking to you.